Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everybody. Honorable all of the committee and the honorable all of the participants in this conference. Let me introduce myself. My name is Eka ENAM'S Hombing as the first author and the presenter. As the second author is Ibnu Sina Chandra Negara. Let me present our result research with the title Defining Political Process under Constitutional Procedure of Making Emergency Law in Indonesia. Article 22, paragraph 1 of the 1945 Constitution state that show exigencies coupled, the President shall have the right to establish government regulation in lieu of laws. Government regulation in lieu of laws or emergency law is an regulation that in terms of its content shall be set in the form of law, but because of the state of exception is set in the form of government regulation. Further, in Art 22, paragraph 2 of the 1945 Constitution state that the House must approve the government regulation in lieu of the laws in the following House hearing session. If then it doesn't get the approval of the House of Representatives, then government regulation in lieu of laws shall be repealed. In Article 228, paragraph 3, People's Consultative Assembly, the House of Representatives, the Regional House of Representatives, and the Regional House of Representative Law state that the House hearing period include the House hearing period and the recess. If the President set the government regulation in lieu of law at the time of the recess, then the next parliamentary hearing after the recess. Research methods. The research method used in juridical normative with a qualitative approach in the form of this decomposing sentence based on legal analysis by examining juridical structure such as legal principle, legal systematic level of legal synchronization, legal history, and comparative law. Government regulation in lieu of law is recognized in line to ordinary law that hierarchically based on Article 7, Paragraph 1, Legislation Procedure Law of 2011. It's because government regulation in lieu have some scope materials as ordinary law. According to Maria Farida, government regulation in lieu of law is equated with ordinary law because it has the same material as the ordinary law. Bagirmanan also suggests that the subject matter of government regulation in lieu of laws is the subject matter of the law under normal circumstances. Such material must be regulated by law. Another debate relates to the formation of government regulation in lieu of law is the meaning of compulsive conflict as the reason for the formation of government regulation in lieu of law. The definition of coercive tension based on doctrine can be found in the opinion of Jimli Asidiki and Bagirmanan. Bagirmanan states that the element of compulsive disorder must show two common characteristics. Among other, there is a crisis and there is urgency. However, in the existence of the Constitutional Court decision stipulated the condition of coercion in the stipulation of government regulation in lieu of law, namely the existence of a situation that is an urgent need to resolve legal issues accurately. The required law does not yet exist until there's a vacuum of law, or there is a law, but it is not enough to resolve. And the vacuum cannot be overcome by making laws by the ordinary procedure, as it will take quite a long time while such urgent situation needs certainty to be resolved. This provision is further elaborated in Article 52 of Legislation Procedure Law of 2011 as follows. Government regulation in lieu of law should be submitted to the House of Representatives in the following House hearing session. Submission of government regulation in lieu of law, as referred to in paragraph 1, shall be made in the form of submitting a draft law on the determination of government regulation in lieu of law. The House of Representatives only gives approval or disapproval of government regulation in lieu of law. In the event that the government regulation in lieu of law are approved by the House of Representatives in a plenary session, the government regulation in lieu of law shall be stipulated as law. In the event that the government regulation in lieu of law do not get the approval of the House of Representatives in the plenary session, the government regulation in lieu of law shall be repealed and shall be declared invalid. In the event that the government regulation in lieu of law shall be repealed and shall be declared invalid as referred to in paragraph 5, the House of Representatives or the President shall submit a draft of law on the repeal of the government regulation in lieu of law. Draft law on the repeal of government regulation in lieu of law as referred to in paragraph 6 regulates all legal consequence of the repeal of government regulation in lieu of law. Draft law on repeal of government regulation in lieu of law as referred to in paragraph 7 shall be stipulated as a law on repeal of government regulation in lieu of law in the same plenary meeting as referred to in paragraph 5. The practical practice is related to the enactment of government regulation in lieu of law number 1 of 2020 on the state financial policy and stability of the financial system for the handling of COVID-19 and are in the face of threats threatening the national economy and our financial system stability. Where the government regulation of the successor law is enacted and promulgated on 31 March 2020 coincide with the third House session related to the meaning of following House hearing session. When the government regulation in lieu of law are set during the session of the House of Representatives, then the following House hearing session after the recess, not during the session when the government regulation in lieu of law. Conclusion. It can be concluded that there has been a deviation in the practice of interpreting following House hearing session in the formation of the government regulation in lieu of law were based on the practice of government regulation in lieu of law set during the session of the House of Representatives is submitted and approved at the same session, not at the following session. Government regulation in lieu of law as emergency law, government regulation in lieu of law are treated as ordinary law because they have the same materials as ordinary law. The material of government regulation in lieu of law must be regulated by law. Government in lieu of law making process regarding the process of adopting government regulation in lieu of law. It is governed by Article 22 of the 1945 Constitution, which states that in case of emergency by the President, the House must approving at the following House hearing session. If it is not approved, government regulation in lieu of law should be repealed connection with the approval of state regulation. Instead of law number 1 of 2020 related to state financial issue and the stability of the financial system for the treatment of Pelin coronavirus in threat to the country economy, uh, or the stability of financial system. Thank you. That's all my presentation. Thanks for all your attention. Assalamualaikum warahmatullahi wabarakatuh.